Let me welcome you to the concluding session of this wonderful symposium on immigration law. I'm Robert Butkin. I'm a member of the faculty here, and our presenters for this session have already been introduced, and it will feature a moderated discussion with our guest of honor, Professor Motomura. But their participating panelists will be Chris Kobach from University of Missouri, Kansas City School of Law, Michael Scaparlanda, our neighbor from down the highway from the University of Oklahoma College of Law, Rick Su from SUNY Buffalo, Wen Pham from Texas Wesleyan Law School, and Wen, I want to express an apology to you from all the people of Buffalo to all the people of Texas. That snow, they would not have missed another 2 or 3 feet of snow in Buffalo, but unfortunately 1 or 2 inches.
Well, they would have shut down the airport.
Okay.
Keep going.
And Sebastian Lantos is also going to be joining us for this panel. He is a entrepreneur, a proprietor of Sebastian Lantos Consulting Company that specializes in language consulting and is also a member of the Governor's Council on Latin American and Hispanic Affairs. Let me now turn over the podium to our guest of honor for this entire symposium, Professor Hiroshi Motomura.
Thank you, Robert. This has been a great and very instructive and helpful day for me to be here and to listen. So this is intended to be an informal discussion, and I'd like to leave plenty of time for folks to ask questions and for the panelists to respond. But let me try to set the stage in a couple of ways. And I wasn't sure until maybe half an hour how I wanted to do this. I'm still not sure. Take a vote or something. But here's what I'm going to do. Let me just make some general observations about the discussion for today that we've had today, and I guess really starting with last night. And then I would like to ask, I have a question actually for each of the 5 panelists, but they have no idea at this point what the question is. And I'm not entirely sure I do either, but I'll have it by the time I ask it. And then I'd like to open it up and see what you all have to ask of the panelists, really anyone that you want to address with respect to a question. So let me just begin with some observations. I think this has been very much a day in the spirit of trying to get ideas out there, ideas for the explanatory content, ideas, as I tried to put it last night, for constructive disagreement if we do disagree about these things. And so, Michael, you quoted Aquinas, and I think, or paraphrased him at least, and I like that. But I'm going to actually frame this session with 3 quotes from 3 jazz musicians. The first is Miles Davis, the second is Duke Ellington, and the third is Charles Mingus. Yeah, that's a good band. Okay, and so the first is I'm going to try to explain what I heard today. It reminds me of Miles Davis once said, "Let me play it first, and I'll tell you what it was afterwards." The other is in the spirit of this whole, I think, is the whole idea of getting together and having this conversation and moving forward constructively in spite of any differences of opinion we might have. Duke Ellington said, "The first thing I look for in a musician is whether he knows how to listen." I know I said yesterday that the rule of law is more complicated than it might seem, and a lot of my argument is that we should appreciate its complexity. I'm going to qualify that and try to bring this down to something much more elemental. And I'm reminded of Charles Mingus that said, "Anyone can make the simple complicated. Creativity is making the complicated simple." So, as I wasn't planning to do this a couple hours ago, but I realized that when I was listening to a lot of what was going on, I was reminded of some themes that I'm working on in this book that is, I don't know when it's going to ever be done, but it's a book about, I think my working title is something like Immigration Outside the Law, but it's really a book about undocumented, illegal, whatever you want to call it, immigration, as a companion to Americans in Waiting. But I was thinking about what I've heard today and about something that I frame in the book, and this is what it is. If it shows up. Did it show up? Okay. There you go. I think that there are really three ideas that we've been working with. What does it mean to be illegally here? Another thing we've been talking about is what's the role of states and cities. That's nominally the subject of this symposium. But I think it's also lurking in the background is how do we integrate immigrants. So this, I think, is how Charles Mingus would look at today. I'm trying to make the complicated simple. These are three big ideas, and this is a lot of what we've been struggling with. Now, let me suggest add a little texture to this, and this is the only other slide I'm going to show. And it's to really indicate that these things are connected in certain ways, and you really can't talk about the role of states and cities, which is this symposium topic, without connecting it to some other things. It's without connecting it in particular to the meaning of unlawful presence, and without connecting it in particular to the integration of immigrants. And so this is what the second slide looks like. So this is what I think a lot of what we've heard today. I mean, you know, for example, that if you look at the role of states and cities, a lot of it is it's looking at it the question of who gets to enforce immigration law. What does it really mean to be unlawfully present? Is that something that states and cities should enforce? Is it not? So that's really the connection. That's why I'm labeling it the question of authority. You know, but you know, Rick was talking earlier in the previous panel about how, well, you just can't look at the states, the role of states and cities as an enforcement question alone. You've also got to think about this as a question of where you build community, and that's when it moves in the other direction, in the community building direction, from the role of states and cities to the integration of immigrants. I mean, there's more I could say about this diagram and about the third part of this, but I mean, that's just a way to understand why it is that I think we've been talking about states and cities all day, but it's hard to talk about the role of states and cities without moving it either in the direction of what do we mean by being here illegally in the first place? You know, is it breaking the law, or is it some more, you know, economic contribution kind of thing, or however you look at it? And you really can't think about the role of states and cities without also appreciating the fact that states and cities have a pretty strong role to play in community building, whether it's education or other things. So that's just an observation. I mean, that's all that. Okay, that ends the video portion of this talk. But so I have a question, and I'd just like to ask each panelist this, and you know, and I guess that I'll ask you to keep your answer crisp, if not short, and then because I want to leave time. But the first is for Chris. And let me just sort of preface this by saying that, ironically, I hear Chris as actually arguing, in a sense, for the strongest role for federal government of these speakers. And the reason it's ironic is because, you know, you've been involved in supporting supporting local government in many ways, and yet it strikes me as that that you're arguing for states to follow the federal lead, and that's one way to think about it. That's just an observation. But here's my question. We've talked a couple times about Plyler versus Doe. Plyler versus Doe says essentially that there's a constitutional right to K through 12 education, regardless of your immigration status. I want to ask you if you think it was wrongly decided. And the reason I ask that question is if you deal with the question of self-deportation and incentivizing self-deportation, I get the sense that there is some line that you would draw beyond which you would not go. You alluded to it when you talked about emergency medical care. And in that spirit, I wanted to ask you to kind of articulate more where you draw the line, where you go too far in incentivizing self-deportation. And this is why I'm asking you if you think Plyler versus Doe was wrongly decided. Okay.
Are you going to stand up? Or
I don't know. I think, are those mics live?
I don't know.
Yeah.
Okay, yeah. Well, whatever's more comfortable, but go ahead. Well, you can sit down. We'll just do this more informally.
Okay. Well, that's a great question. Plyler v. Doe, as most of you probably already know, came out of Texas, and it was the decision was catalyzed by the decision of originally I think it was just one school district to require unlawfully present alien families to pay the cost of educating the children in the K through 12 education. And an equal protection challenge was brought to this, and it went all the way to the U.S. Supreme Court, and the Supreme Court decided by a 5-4 decision in 1982 that the Equal Protection Clause does protect the right of children of unlawfully present house parents. And, well, actually, the question was even for the children. Unlawfully present K through 12 age children to receive a free public education. And those of you who teach or study or have an interest in constitutional law may be aware that it was a curious decision because the court did not find that education is a fundamental right. There are basically two ways you get to what's called strict scrutiny in Equal Protection Clause cases. You either have a fundamental right at issue, in which case the state law is subject to strict scrutiny, and that usually means the state law loses, or you have a protected class, a suspect class that is of the highest order, like race. And the court also said this isn't a case involving a suspect class because alien status is not one of these special classes that we give strict scrutiny to. And so the court did not apply strict scrutiny. The court applied only rational basis or minimal scrutiny to the case and still came to the conclusion that the state should lose and that there was no rational basis for the state's law. And actually the factual findings of the case then were very different from what the factual findings would be today because in 1982 the volume of illegal immigration into this country was much lower than it is today. We were only talking about a couple of million, or some people say maybe somewhere south of 5 million. And the court did not come to the factual finding that there was really that big a burden on the K through 12 education system in Texas. And of course, today it would be hard to come to any other conclusion that there is a pretty significant burden. At any rate, I expect that probably if that case came to the Supreme Court today, it probably would go the other way, just because it's very difficult to apply minimal scrutiny and the state to lose. Now, that's a different question. That's a legal question. As a legal matter, was it correctly decided? It was always tenuous then, and I think now that the facts have changed, and these decisions are to a certain extent fact-bound because you have to show a rational basis in light of the facts, I think it might come out the other way today. As a policy matter, I don't think Plyler v. Doe has to be overturned for attrition through enforcement or self-deportation to work. Because although certainly there are some people who enter the country illegally with the intention and hope that their children will get the finest K through 12 education in the Western Hemisphere, that's probably not the driving factor for most people. And similarly, even though let's suppose that E-Verify was mandated nationwide and suddenly it became very difficult to illegally get a job, the mere fact that your child still could get free K through 12 education probably would not be enough to keep most people unlawfully in the United States if there's no job or if suddenly the job prospects dried up. So I don't think that it's necessary to remove that public benefit in order for self-deportation to work.
Okay. Thank you, Chris. Michael, I have a question for you. And that is, I was struck by your comments about the church, and you started out by mentioning what I had said about different ways to recognize ties and this kind of thing. But there was a difference between, I think, the way I was approaching it last night in terms of trying to give texture to what it means to be, say, to have constitutional rights in this country based on ties and all sorts of equities. I was trying to express that in the language of American constitutional law. I was trying to use that to give content to or give rationale for discretionary relief from removal, things like that. And I think that you expressed in your remarks kind of a sympathy or at least adopting that way of thinking about it, and yet you kind of ratchet it up in a way to sort of analogize the civil disobedience and talk about a higher law, natural law you talked about. What difference does it make if you take these ideas of people's equities that they've earned in this country, equities about which there's disagreement, but if you take those equities and you phrase them, what difference does it make if you phrase them in terms of higher law and the call of the church, as opposed to what I'm trying to do, which is to try to, and a lot of people are trying to do, which is to make that part of the Constitution of the United States as a matter of national law?
Yeah, well, a couple of things. One, my larger project, which is not part of immigration specifically, but my larger project is how do we live in a what's the foundation of our pluralistic republic? And is there a secular foundation? Is there a religious foundation? So what's the place of religion in the public square? So I'm thinking about those issues more largely, which do have obviously some constitutional implications. The other thing, and I wrote an op-ed piece for the Daily Oklahoma City paper a couple of years ago on this. The other thing is in a state where there are many evangelicals and other Christians, I want to just ask directly the question. So I think partly it depends upon the audience. I think what you're doing is wonderful, and for particular audiences that are people of faith and who want faith injected into the politics and the public policy in other ways, which I do too. I get labeled the conservative at our school. I want to ask them the question: if you want to inject faith into this, then I think you have to ask the deeper, or the higher law question of what's the moral basis for these laws. I don't know if that answers your question.
Yeah, well, it's a great answer. I mean, the reason I'm thinking about this is in terms of the larger framework. Yeah. Part of this is sort of, do you make the national citizenship and those kinds of constitutional values the frame, or do you make it or do you make some other frame, which could be religious, it could be it could be transnational, it could be all different kinds of things. I mean, one of the most interesting experiences I've had, I think the first time that I gave a talk about my book, it was at a religious conference where I was the only non-clergy speaking, and I never forget the moment when a woman who was a pastor of the local church said, "Well, your sacred text is not my sacred text," and we talked about how the Bible and the Constitution were similar and yet different. When I have a question for you, which is, it goes to this question of success, and it goes to the question of time frame, because I think one of the interesting things that thoughts that you provoked in me as I was listening to your talking about success is the question of time, and it's often heard on behalf of people who I think you would substantively agree with in terms of overall immigration policy that it might be unfair to judge the contributions of immigrants just on this generation and just on the immediacy, that you also have to recognize that immigrants make a long-term, multi-generational contribution to their kids, even if they are a net loss to the budget in this generation, that their kids will become Nobel Prize winners. And you're making the argument that states and localities really may not have been as successful. But the question, I know this is kind of a more vague question, but isn't it too early to tell? Isn't it too early to draw conclusions against state and local ordinances of this type on the basis of a couple of years? What would you expect to see over time if you were to take that out further?
I think you're absolutely right. I mean, we think about measuring success of any program, we've got to have enough of a track record to make it statistically valid. And so I guess maybe my lawyerly caveats, I didn't emphasize enough the limitations. But I think what I was trying to talk about was we focus a lot of attention on the passing, the enactment of these laws, whether local governments have the authority, the policy debate and the enactment of the laws. But I wonder, and I think this is a question that deserves closer scrutiny, are they really achieving even what the drafters of these laws want them to achieve? And that may not be something we can tell until we have sort of a longer track record and quite frankly, more systematic ways of analysis, tracking, study, and so forth. But I'd suggest that we should at least consider it because we're devoting an incredible amount of energy and resources to passing the laws. And if we think about, at least short-term, the costs, and I think this is a question that local governments are facing, which is it worth the cost, particularly at the local level when they've got sort of more, they've got competing bread and butter issues, schools, roads, and so forth that they have to, at least financially, have to pay for.
Yeah, thanks. I just want to raise that because so much of this, I think I was trying to mention this a little bit last night, so much of this has to do with the time frame and the comprehensiveness, not just in terms of subject matter, but the time that these things take to work on. I'm reminded of, you've probably heard the famous quote from the former Chinese Premier Zhou Enlai about 20 years ago. When he was in power, he was asked to discuss the effects of the French Revolution. And his answer was, well, it's really too soon to tell. Okay, so Sebastian, I have a question for you. It's really an opportunity for you to respond to what Chris said earlier about the distinction between criminal and civil violations. It's true, as you suggested, that being in the country per se is not a crime. But given that there are criminal penalties for some of the things that are done by people who are here outside of lawful status, given that some of those individuals have committed criminal violations, does that change your mind at all, or does that not matter?
The point I was trying to make was there was a marketing and promotional, if you will, social marketing campaign from the anti-immigrants, and part of that was labeling everybody that's undocumented as a criminal, that they don't pay taxes and they're taking jobs from the United States. Any decent citizen at face value or resident would say this is something very worrisome for me, and we need to take care of this problem. At this point, I don't think that every undocumented person is a criminal. Now, if we unbundle it and we look at the different categories, there might be some that are criminal behaviors, like, of course, representing yourself as a citizen or showing some false documentation, which I did not allude to, because that can happen also. If I show false documentation, I'm a citizen. If I'm a citizen, show false documentation, that's also a crime. I'm alluding to the point that not all undocumented people are criminal, but this is what was portrayed to magnify what we have right now, which is 1804. And so, no, I'm not changing my mind, but even if every undocumented was a criminal, even if that was the case, I think it's time for that law to change, because not all undocumented people that come here to the United States behave in a criminal way. They come to work. And the same way as Rosa Parks was in the front of a bus in 1963, she was probably labeled that way. And if she was a criminal, I would have stood next to her and said, you know what, you're not a criminal. So that's the same thing I'm doing right now. But the third point is, that's why Congress, when they were debating this issue about who are we going to give this legislative amnesty or whatever you want to call it, they did make a distinction. They said if you have a criminal record, you will probably not get the benefits of being of having an amnesty or having papers. So they themselves recognize that within the undocumented population, there's people, yes, they have a criminal behavior, and again, I'm a court interpreter, and I agree with what the law says there, but I don't think that qualifying every single undocumented person as a criminal helps this debate.
Thank you. And last question I have, then I'll turn it over to all of you to ask, to direct questions to any one or more of people here, is for Rick. I really appreciated what you're saying about the different types of borders and communities. In fact, one of the reasons I put that chart up there was to show you that I agree with you that the role of states and cities has to be looked at not just as an enforcement and the role of enforcement, but also the place where you build communities. So that's the Rick Sue part of the triangle here, and I really think about it that way since I cite you in the part of my book draft that talks about this. A lot of this is about moving inside the United States. You're talking about North Carolina, and I Some of you may know that in one of the communities that's close to the Research Triangle Park, with a lot of people from the north have come in, it's called Cary, North Carolina. But Cary, North Carolina stands for the Containment Area for Relocated Yankees. So that's just local lore. But anyway, my real question, I'll rephrase it in a way that is going to seem less goofy. But my real question is, what did the American Civil War decide? But I know it's too early to tell. But here's what
French Revolution first.
Yeah, right. That's right. We'll work on this. Right. Yeah, French Revolution. But here's why I asked the question. I think you're right that local boundaries count in a lot of ways, but they count differently, don't they? It's like, you talked about not being able to send your kids to a certain school, or you're not being able to use a public library in the neighboring town, and that kind of stuff. But this is in a sense more of a response I'd like you to comment on than sort of a pure question. But it seems like a lot of what we've done is created a national citizenship, at least with regard to freedom of movement. And there are cases involving actually people going from Oklahoma to California, like Michael was talking about. Or maybe it's to Nevada. But at any rate, it's going west from here in search of economic opportunity. A lot of this was about establishing at least freedom of movement. Now, of course, the response might be, well, but there's still money, right? You can't buy into these communities that require residents in order to have a library card. But I guess the question really comes down to that even if local governments, or even if there are still these barriers, isn't it a different kind of barrier when people at least can move to take advantage of those things? So that's part of the observation I wanted your response to. But the other part that follows from that is, doesn't it really matter the kinds of things local governments do? Can they do some things, or can't they do others?
Yeah. No, I think that's an excellent question, and I think. I don't want to give the impression that the borders are the same, but we don't have to look at the national borders versus local borders. We can manifest all sorts of borders. We can go all the way down to the family. What I'm trying to do is sort of situate them on a spectrum. And I want to see these things as actually really similar and familiar in a way along a spectrum, from all the way to the national border, all the way to the local border, and even very interpersonal borders at that point. And I think one way to address, the question coming through, especially when you mentioned the right travel cases, right? Part of the interesting thing is that actually Professor Chang has argued that. Though I think it's a little limited, but he has argued that we don't have any restrictions on interstate travel, but we have extreme restrictions on international travel. But I don't think that tells the whole story, and I think a lot of the local perspective. On the one hand, you have Science versus Roe, right? Right to interstate travel. But on the other hand, you have Worth versus Selden and Village of Belterre, which really manifests an idea that a community at the same time should be able to define what that community character is and that sort of sentiment that arises from it. So if you see that whole spectrum, I think you get, on the one hand, an idea that, whether you want to go, we're a cosmopolitan global world, we are a national, unified, post-Civil War, privileges and immunities sort of community. But all this sort of contrasting with the idea that, well, wait a minute, we think we should be able to define our community. We think that we should be able to decide where we live and be able to sort of build our own community, and just like the way we build our family, and that means something. And I don't want to give the sense that, I think that the economics part is very important, and I think a lot of the symbolic function is really important, but I don't want to give a sense that, when people react to these situations, it's very personal. It is in a way that is very much dear to their heart, but I think there is always that tension. There is always a tension of line drawing as a precursor to building a community, a Michael Walzer communitarian perspective, versus an idea that we are all sort of individuals and that we should have sort of a free flow. So I see this, whether you want to go a spectrum from national border to local border, or whether a spectrum from sort of liberal cosmopolitanism to sort of, communitarianism, whether you want to go communitarianism or even more personal communitarianism on the spectrum. So I do see them as sort of interconnected. Although, along the spectrum, you can say whether with regard to specific powers, with specific ability, they do vary. But I think that's just negotiating these two poles.
Mm-hmm. Well, Those were my questions. I'm sure many of you have questions. And then, Ann Betsy, do you want to come up and I just want to. Okay. Yeah, go ahead.
I have a couple of questions, things that have not been mentioned here today. And I'd like to address Mrs. Fan and the others, Chris. But first, about how to pay for it was mentioned, the cost and things of that nature. Well, we've got a big prison system that's bulging at the seams of 2.5 million people, more or less, and a high percentage of them are in there for drugs, hot marijuana or something or the other. We could use those people on a ratio of 4 to 1. They've got 4-year sentence. 1 year they sign up like they do the Peace Corps or AmeriCorps and go to work in agriculture, food industry, the packing industry. And therefore we can reduce that population, use that money towards enforcement of what we got to do with immigration. And it's a pool of people. The other thing from over here, back in the days of Carter, the mid-'80s, he had an amnesty program whereby we gave amnesty to some great number of millions of people, and it didn't work. We had to marry a boat rip. Castro outsmarted us. He said it opened his prisons and sent his prisoners to the United States of Florida, and here we are, back filled up to 12 and the same 20 million people. So we're not winning.
Well, Lynn, you want to take the first question?
Sure. I think, you pose an interesting proposal, and I think actually what you're talking about, I think, if we think on a big picture level, the question is economically, who does immigration hurt and who does it benefit? And I'd suggest that in terms of benefit, as consumers, we all benefit from lower prices for services, for products. And who does it hurt? Arguably those with the least skills, and prisoners are probably a big part of that group. In Colorado, I think I mentioned during my talk, faced with labor shortages, shrinking numbers of migrant workers, the state did try a pilot program to send prisoners out to pick crops. I guess two questions I think about when I think about, perhaps using prisoners to replace immigrant workers. From an economic perspective, what's the best result? Right? Are these prisoners going to be the best qualified to do these jobs? Are they the best workers? And the second question is, who gets to choose? That is, you ask employers, they don't want to hire prisoners. They'd rather have probably immigrant workers. Do the immigrants get to choose? As consumers, do we get a choice in who does this work? In terms of your specific proposal, one thought I have is that it's not exactly cost-free to have prisoners do this work. That is, they have to be supervised. They may not have the skills to pick crops. If you have someone coming from the city who doesn't really know what, ripe fruit looks like or how to tell the difference between ripe and unripe, you've got to have some skills training. And there are probably other issues. You talked about prisoners with drug problems. That would also have to be managed. And so they're not going to be the best workers from a productivity perspective. So what's the best result and who gets to choose what's the best result are some questions I'd have about your proposal.
Chris, you want to comment on the 1980s and any connection possibly with the Mariel boat lift?
Well, I think just dismissing addressing the Mariel boat lift. I think the Mariel boat lift probably incident where Castro did invite relatives of Cubans who wanted to leave the country to come get their relatives and open the ports. And then when the ships arrived, he said, "And you're taking these criminals with you." And and of course it was the Mariel boat lift that indirectly led to the Zabidas case, where one of the litigants one of the litigants in Zabidas I don't remember.
No,
Anyway, no, it was not Zagos.
You're thinking of the case that came afterwards.
That's
Clark
right.
versus
Clark,
Fortune.
yeah. Right. But the bottom line, I think that would have happened regardless, because our laws regarding Cubans are defined more by the Cuban Adjustment Act, which gives sort of a special, golden path to citizenship for people who are Cuban nationals. So I don't know that the amnesty caused the Mariel boat lift or caused Castro to act, but I would say that the 1986 amnesty to which you refer, which did legalize approximately 2.7 million people who called themselves seasonal agricultural workers, because that's what the amnesty, that was the category you had to fit into. It did prove to be a failure in a couple of respects. One is that it was just a wide open door for fraud, because of the cases that the INS actually discovered that someone said, in which they said they were a seasonal agricultural worker, there were 398,000 cases where the INS said, no, this is fraudulent. We've got someone here who's just coming to get the amnesty. And some people even came in after the amnesty was issued and quickly applied for the amnesty. And so it created an incentive to quickly come across the border. And we saw that in 2006, 2007. Border Patrol reported that once it got in the news that an amnesty was on the table in Congress, that some people said they reported a slight uptick in legal crossings. The other thing that we saw with the 1986 amnesty is that our status adjudicators, they're totally overworked, and they had limited resources then. They have better resources now. It's very difficult to determine when someone coming to you and presenting a name to get an amnesty, whether that is their valid name and whether and what their past background is, because, especially when so many countries don't cooperate. And frankly, our adjudicators don't even call their home countries because they don't have enough time to find out whether this person has a criminal background. And as a result, two of the ringleaders in the 1993 attack on the World Trade Center received amnesty under the 1986 amnesty. And one of them, I remember in particular, he claimed that he was a seasonal agricultural worker. In fact, we later learned, when he was arrested for the 1993 attacks, that he had been driving a cab in New York. And so the system is fraught with fraud, and unfortunately, we have not progressed to the point where we could administer an amnesty any more effectively or expect any different result today if we did so.
Other questions?
Can I?
Yeah. Well, yeah, and I'd like to also give the panelists a chance to respond to each other, and then we'll why don't you go, and then we'll take some more questions.
Sure. I'm not sure if I had a farm, why would I take a thief and a drug addict rather than an immigrant to work? I'm sorry, I don't understand the point. I think if we're going to choose someone that's incarcerated and that person, choose that person rather than somebody that has proven abilities, I'm not sure what the motive is. The borders, I agree. I think that's why IRCA in the 1996 laws failed, because we just can't have the same system repeating itself where we give the opportunity of good, undocumented working aliens the chance to stay and integrate in the United States, but not have a safe border. So that's the modern position, I think, of the Hispanic community, and it's always been said that way, that the borders have to be safe before we do any plans, so then we don't repeat what happened. We went further more to suggest how. And the way to make a border safer is to get Mexico to help us. A border is a marriage. So if they have a buffer zone, and then we have our border patrol, and we tell at that time, I remember talking about this, if Mr. Bush would tell Mr. Fox, we're going to not tax all the money that we're sending to you that you need so much, but you need to help us in the border, I think that would have been a nice poker game to do with Mexico. That's how we control the border, with Mexico helping us, because we can't have this every generation in this discussion. I mean, it's killing us. The Mariel issue is kind of interesting. I don't know if it has to do with the discussion, but they were not all criminals. It actually started with professionals that hid it in the Peruvian embassy. They're not, when you hear Mariel, that's another myth. You just can't say all these people that came with the Mariel lift are criminals, because they're not. I've been actually in Cuba for four times for the government researching this. And then the adjudicators, I don't know if they have time or not, but my understanding is that they do check the background information of people nowadays. I don't know if the adjudicator does that. I think they send it to the country where these people are from, and then in the embassy or the charge d'affaires, they will look into the background of these people. Now, if it's open for fraud, definitely it's something that we need to take care of, but I just wanted to clarify those points.
Yeah, before taking another question, there's add a couple of things. I mean, you're really right about the generational piece. If you actually look back at American history, it really comes around about every generation. I mean, it's Mark Twain once said that history doesn't repeat itself, but it often rhymes. And that's think about this. This is 86 you're talking about, and now we're talking a generation later. And I think that, I made a comment last night that reform, what you think of as like a big reform. It was the Immigration Reform and Control Act, right? When you think of that all it really buys you another generation to fix some real issues, which apparently didn't happen. But if you go back a generation before 86, you've got a big change in the legal immigration program in 1965. You also, interestingly for this context, have the end of the Bracero program. So, and then before that, if you go back a generation, then you have an event that really puts the brakes on immigration entirely for a period of time, which is World War II, preceded by the Depression. And before that, then you get into the period of the national origins quota and the sort of the shutting of the doors of Ellis Island a generation before that. So that's just to show that there's a cyclical quality. Another observation I wanted to make, and that is about the IRCA. It's interesting to think about the sort of the amnesty versus legalization kind of not just semantic but also substantive debate. One of the interesting things about the IRCA thing, though, is that to the extent there's a concern about integration, there is in IRCA, there was more demanded of people in terms of, language and things like that than we normally require for people who are coming in to have green cards. So it's an interesting kind of a trade-off. I think that we gave a lot, obviously, in terms of legal status, but we also kind of demanded more, or at least asked for more than we normally do. And that's kind of an interesting trade-off. So I throw that out as kind of a thought about as we go forward, if there's going to be a legalization program or whatever you want to call it, what that's going to be like. And I also mentioned the Bracero program because one of the big factors in this debate that I just want to identify because it's come up here and there, but it's a really big issue, is how much of this so-called immigration reform is going to be in the form of permanent admissions, and how much are we talking about a reintroduction of something like the Bracero program, and what would that be? So I just want to throw that out. Sir, you had a question?
I've heard a lot of stuff today that's been largely anecdotal and utilitarian, even emotion-based in the arguments. That's not Mr. Kovac, who addressed one of my concerns is the rule of law. Prior to graduating from this school and going into law, I spent 20 years as a cop. I've got my own anecdotes about dealing with a lot of the effects of this. And now that I'm working criminal defense, I can analogize something that I see that actors within the system, judges, politicians, whatever, decide that, well, they don't like the rules, so I'm going to put my own spin on it, like you routinely deal with this fact of cops around here exceed the limits of Terry versus Ohio and produce the dope they find on our client so that we can make the argument in court that they exceeded what their constitutional authority was to make a search, and you got the judge that, yeah, I understand, it's true, but he had dope on him, so we're going to do what I think we ought to do, and we're going to bind him over to trial. So we're getting, like I said, these utilitarian arguments. We're not looking at the fact that Congress specifically has plenary power over who's an alien, who's not an alien, who can be in, who can't be out. When they define those things, that is the law. We get analogies to Rosa Parks and these folks. Forgetting that Rosa Parks and Martin Luther King were part of a group of people that traditionally in this country, one, were enslaved, and two, were the exact subject of three constitutional amendments, 13, 14, 15 amendments, which all had clauses that said Congress can address their problems by appropriate legislation. They were still denied those from 1874 until you get to what is needed, the 1964 Civil Rights Act, and then some of the remedies of the Warren Court saying you deny these people their rights based on the fact that they are citizens of the United States and they have constitutional rights as citizens. Okay? They're not in the same group. So what I want to know is, are we going to continue down this road of, well, it's not quite fair, even though the law says this, or are we just going to let all our political actors and our judges decide that we got equitable powers as well as legal powers, and so we're just going to declare that that's not fair. We're just going to all let them in.
I'm just reminded that I was asked to repeat the questions, but for the people, to people in the pit. But let me just invite any panelists who want to address this and just say that the gentleman's question relates to the rule of law and the line between citizens and shouldn't citizens. Isn't that the difference between Rosa Parks and the situation that Rosa Parks is a U.S. citizen? Anyone want to?
Let me take a stab at it. First of all, I think that the 14th Amendment, Equal Protection Clause, Due Process Clause, the 5th Amendment, Equal Protection Clause, and Due Process Clause refers to persons and not citizens. And so persons who happen to be here are entitled to some protection. Now, the question is, what sort of protection does the Constitution provide them? And this is why, and to answer more fully Hiroshi's question earlier, why I talk about the higher law, because oftentimes the court gets it wrong on the Constitution, I think. They got it wrong, I think, in Dred Scott. They got it wrong in Plessy versus Ferguson. They got it wrong in Korematsu. I don't like the result in Korematsu, but I think they got it wrong in a lot of these cases. And so what Martin Luther King Jr. was doing was appealing to, one, people's consciences, and also to a higher law in saying, is this interpretation of the Constitution a just one or is it not a just one? I mean, we tried lawyers and judges in Nuremberg for upholding the law, for participating in a legal system. Now, I'm not comparing anything we do here with the Nazis, don't get me wrong. Far from it. But the point, the small point is, we tried and punished people for following the law, because we said the law was unjust. So I think, one, the Constitution protects more than just citizens, and that's clearly established. And second, what's a just interpretation? So my stories are just meant to kind of get us into the legal debate. But I agree with you, and we can't just rely on stories. We have to get into the justice of it. Thanks.
Anyone else who want to? Chris, you want to?
Yeah, a couple of things. I mean, I agree that obviously the 14th Amendment, except for the Privileges and Immunities Clause, does refer to persons, not citizens. The Privileges and Immunities Clause refers to citizens, and that's a fascinating historical debate. What would have happened if slaughterhouse cases had gone the other way and slaughterhouse became the mechanism for incorporating the Bill of Rights? We'd be in a very different situation today. I think the breakdown of the analogy to the civil rights struggles of African Americans in the 1960s versus the issue today is, of course, that a person does not, by acting, become African American, where it's not something that you choose to do, whereas there is a willful act in violating federal immigration laws. I think that's the more salient distinction between the two. But you also mentioned about, what do we do about judges or politicians who, see the law and then they spin it their own way? And I think the last commenter talked about, judges. I think it's one of the things you see at the state and local level, which I see all the time. I get calls constantly. In fact, just while the last panel was going on, I was talking to state legislators in 2 different states who happened to have my phone number and said, okay, can we do this? And I'm constantly telling state legislators, no, you can't do that. There are certain things you can do that federal law allows and the standards of preemption allow. You can deny public benefits. You can impose licensing sanctions on employers. You can increase state and local cooperation. All of these things which are part of HB 1804. But there are a lot of things you can't do. You can't deny emergency medical care. You can't deny K through 12 education benefits. You can't. Some states want to go the other way. They want to create their own immigration system. They want to have their own work visas and issue. They want to make a decision at the state level. Well, we would like X 100,000 people to come work in our agricultural fields, which actually might be very interesting. And some professors, like Peter Schuck and others, have proposed that maybe we ought to devolve the granting of status and the granting of visas to the state level and let them make some of those decisions. Well, that's an interesting debate, and there's some good arguments for possibly doing that, but that's not the status right now under federal law. So a lot of what I do in my practice side of my life is tell state legislators no. And some state legislators want to go the other way. They want to reward illegal immigration, or at least provide benefits that others get also to illegal aliens. And of course, most notable in that would be the 10 states offering in-state tuition to illegal aliens, which, by the way, Oklahoma still is one of. That's one of the things that 1804 did not change, and that Oklahoma still provides in-state tuition benefits. And there's a federal law that says you can't do that. That was also part of the 1996 Act. It's found at 8 U.S.C. 1623, and says you're not supposed to be doing that. So at any rate, states may wish to go in a more permissive direction. They may wish to go in a more restrictive direction. But under our standards of federal preemption, there's some things you can do and some things you can't. And I think it's important that states, because Congress has plenary power, the states do have to respect the boundaries that Congress sets. If Congress wants to widen the boundaries, they can. But that would take another act of Congress. Yes.
I might have your name incorrect. I apologize if it's Mr. Kobach.
Kobach.
Okay. Earlier in your discussion, you talked about amnesty programs and legalization programs and the problems that have occurred in previous programs. And under the 245I, which I would not call an amnesty program, I would call it a legalization program, those participants had to qualify in exactly the same manner as if they had been out of the country, and that they had to have sponsors, they were investigated by the FBI, and all kinds of things in order to qualify, because they had to pay a really hefty fee. And my question is, can you also say that that harmed the country in some way? I mean, from my practice, I don't see the harm, but it might be there, and I was wondering if you could enumerate a specific incident that occurred under that legislation that harmed the country.
Yeah, let me just for the benefit of folks outside, and also for anyone who may not know what 245I is. 245I is a provision that allows people to get a green card, become permanent residents while they stay in the country. It expands eligibility for the process of getting a green card, and by allowing people to stay in the country, it basically not only streamlines the process for getting a green card, but it exempts them from certain bars that might apply if they were to leave the country and try to come back. So some people think of it as amnesty, some people think of it as merely opening a procedural mechanism.
Well, in answer to your question, no, I can't name a person, like as with, the numbers are just much smaller with the 245I population. I can't name a terrorist, for example, like I can who was granted amnesty under the 1986 Act. But do they cause problems? I think in a general sense, 245I amnesties or procedures also do have some of the same problems that a broader amnesty has had in the past and would have in the future, one of which is the screening. And the comment was made, maybe these adjudicators really do have lots of time. No, they don't. If you know anyone who's a status adjudicator, they will tell you that there's an informal 6-minute rule in place, that they are expected by their superiors to process 10 applications an hour. And not only that, they're given financial benefits if they meet certain goals in processing applications quickly. And so, that's a problem in our system. And I think one thing I would hope that we would all agree about in this room is that we need to have more status adjudicators, because whether we are a very generous nation when it comes to our immigration benefits and giving people an adjustment status, giving people green cards. I mean, we're handing out 1.1 million green cards a year now, and that's just extraordinary. No other country in the world comes close to granting permanent residence in numbers like that. But in order to do it well, and in order to screen people who actually have a criminal background, we need more status adjudicators, and we need them to spend more than 6 minutes on these. Right now, they don't make calls. They don't even call state governments to find out if a person who got married, and find out if the two people who allege to be married are actually both under driver's licenses under the same name. That regularly doesn't happen.
Well, I had a letter yesterday from the. I mean, I'm not trying to have a disagreement.
No, go ahead.
It's an example. I had a letter yesterday where I had one client married an elderly client, and they not only checked on him, they called him, they went over there, they interviewed him personally in his house, and they worked on MySpace to investigate him. So they're not just looking at criminal records, they're actually doing their job. And I would think the harm is not, the source of the harm doesn't appear to be then the immigrant. The source of any harm seems to be the system managing the immigrant under our law.
Sure, there are lots of immigrants who are entitled to the benefit, have not committed any crimes, and would not present a threat. When I talked about not making calls, sure, they definitely make calls to the immigrant's family and to the other people who can provide some information as a basis for that application. But what they don't make calls to are the state agencies who could verify, did this person apply for a driver's license under their new married name, which would provide corroborating evidence that they are in fact married. They never call foreign countries and say, hey, can you do a record search and get very rarely. I've talked to status adjudicators whom I've worked with and whom I still correspond with, and they say, no, we just don't have time. And so while you might get a case where you have a really careful, persnickety status adjudicator, most don't because they're under such time pressure. Yeah, it's a matter of funding, and it's a matter of hiring, too, because even if the money were suddenly appropriated, it takes a long time to hire and train these people. And then the final point is there's one other general problem that's caused by even smaller amnesties like 245I, and that is just the general breakdown of the rule of law. If some people notice, hey, wait a minute, I heard he got an amnesty, and here I am, back in the home country waiting and waiting and waiting. So there is, every time we reward someone who's broken the law, it kind of sends a message to the people who are waiting in line and who are actually outside of the country trying to get lawful status to come in. It's kind of a slap in the face. Hey, you didn't have to wait here.
Ann, did you want to speak to this Ann Chandler?
Ann Chandler, Houston may be an aberration, but last week I was up there twice, and it seems to me systematically officers have 2 cases an hour. And in fact, both the cases I have where adjudication was held up to check with embassies and their local government for verification of death certificates or other primary documents. One involving a Nigerian 17-year-old, where a state court had already made specific findings as to death of both parents. So I question on just a factual level a little bit of the basis, and that this is such a flimsy, overburdened procedure that we can't grant or extend something from 245I. But I think on a more a different level, regardless of whether those facts are true, we do have the power to fund these agencies to get the job done in a way that is satisfactory to our level of security and checks and balances. And so I think to justify not permitting the unification of families that are here that could so greatly benefit from regularizing their status is really an injustice to what we stand in as a community of peoples. And this idea that we're breaking the rule of law, I think in many folks that we come across in our daily practices, that kind of blanket statement just kind of falls through the cracks. I mean, we work a lot under the Violence Against Women Act, where individuals that are immigrants here and are undocumented or come in as an illegal entry don't always do that on their own willful, purposeful account. Our immigration system is one where those, the employers, and the citizens and the residents that have power, invite the dependents, the immigrants. And it's often those that have power that are in control of the strings. And so to say we're now the individuals who maybe are abused or left out, or there's some administrative loophole that they got stuck in, to say that we're going to punish them because now we don't have enough administrators to check the primary documentation, I think really is not sound policy and where we want to go. So that's some of the balance.
Just add, there is a GAO report that came out in March of 2007 which talks about the problems of status adjudicators being overburdened. They don't come up with a specific statistic of how many per hour because it's all, some offices are light, but the vast majority of offices are totally overburdened. But anyway, GAO report, February or March 2007.
As long, by the way, I know there are more questions, but let me just interject one thing that I think is a theme that's worth identifying and that's really run through the whole day. And that's really the role that history plays and the burden of, in a sense, the burden of history. I mean, you raise adjustment of status, and now this sounds like a very technical thing. It's just a way you get a green card without leaving the country, because the so-called normal method is you go back home and then you return, with the immigrant visa across the border. It's interesting kind of a thing, and by the burden of history, I actually mean something that when you mentioned earlier, sort of about the perception, even if everyone is sort of well-intentioned, the perception that this is about race and about messages of exclusion, even if it's not always intended that way. And what's interesting about adjustment of status is we think about this now as kind of a neutral procedure and something that is just sort of you can argue about whether it's amnesty or whether it's just a procedural avenue. But what's interesting about adjustment of status and similar systems or mechanisms for getting a green card is that they were there for a significant period in the mid-20th century. They were only available to Europeans and Canadians, and not to Mexicans. And so, what does that tell you? I guess it tells you that there's a perception reflected in the law that if you were from Mexico and you committed a violation, that was a real serious violation. But that if you were from Canada or from England and you committed a violation, that was just technical. And then you were able to resort to adjustment of status. Now, and that's just a more technical example, I think, of, in a sense, the burden of history here, because I think that some of the debates today are about whether or not, our historical record, which has been very discriminatory in the context of immigration and citizenship law. I think that one of the ways to interpret debates or suspicions, I suppose, is one side that would say, well, wait a minute. I mean, this has always been a racially driven, even racist history in the past. That's kind of the background to which you might say, well, what's going to change now? And the other side would say, with equal good faith, I think, that well, wait a minute, we're going to wipe that slate clean, and we're going to do things neutrally from now on, and we have at least since 1965, and so don't be so suspicious. So that's a little bit what's going on here, I think, and the burden of history is one that. And this, is honestly why I raised the Civil War too, because I think that the whole question of states' rights and local rights in this country is burdened by the history that's associated with so-called state rights, and yet we know also that states' rights can be much more benign. So, yeah. Okay. I mean, the question has to do with commenting from the perspective of other countries, Europe, and so let me take a stab at that and see if anyone else wants to jump in here. But this is how much time do you have? I think it starts out with some things. To answer your question, I think this debate is going on all around the world. I mean, there's no doubt about that, and that only reflects the fact that this is a reflection of, what some people call globalization or international economic development. It's also a function of world conflict. I mean, that's what also drives people in a mixture of political, environmental, and economic push factors. So it's going on all around the world. Now, that's the first comment. Second comment is I think that you have different national traditions. I mean, I think you have countries that sort of see themselves as nations of immigrants. Of course, the United States, it's part of the national lore, Australia, Canada, South America to a significant extent. And then you have countries like in Germany, where I've lived for, about 3 years, actually, where the standard government line is that we're not a country of immigration. But that's changing, and now, Germany is going through the same kind of things. And if it's interesting, if you go someplace like Dublin, you'll see that it's really become the opposite of the traditional Ireland of people sending people to the United States. It's become really an migration country, which is really interesting too, because it also points out the power of international economic development to change flows. But I think you're having different kinds of debates in those countries, and the traditions are, I think, more begrudging. But I think that you have the same thing going on with the recognition of the reality of people coming in. Now, with the European Union, you have a different relationship between economic integration and the movement of people, compared to what you have with NAFTA, for example, because in this hemisphere, because in the European Union it could be looked at as a model, or at least something we're thinking about in terms of allowing for free movement of people, to be going along with the free movement of goods. But there too, there's a lot of issues, because the new EU countries are not countries that are given fully the rights to a free movement. So that's a different kind of answer. Let me just give one other mini answer, and then see if anyone else wants to address this. But it also has to do with consciousness of the public culture. I think that someone I know who worked a lot on comparative immigration law told me that he goes to conferences in different countries about how they think about immigration. And it's really interesting to him. He said, well, if you go to an immigration conference in the United States, it's all a bunch of lawyers. And if you go in Germany, it's all a bunch of demographers. And if you go in Japan, it's all labor economists. And that tells you a lot about how each society thinks about this question. I think we tend as American society and public culture to think about this as a matter of rights in some ways. And it balanced with the community thing, right? But there's that kind of thing. And it's interesting, in a lot of other countries, people don't necessarily think about this in terms of rights as much as sort of like managing or understanding flows of people. So that's another thing. I told you this is going to get me started, but let me just say one other comment that I think that it's interesting. This gets back to what Chris was saying. I think it's interesting that this country gives people green cards at all, because one can imagine a system where you didn't give anyone a green card and you just said, we'll let you in for 1 year. You can extend it. You can extend it, and then if you are here for 6 years, then you have some kind of a durable right to remain. That's the German system, by and large. It's interesting that this country, the green card itself is an interesting manifestation of the idea that you actually identify people at the outset as you're an immigrant. And that's an interesting, those are just some observations about immigration in other parts of the world. I have to stop because otherwise I'll just never stop on this question. Go ahead, Rick.
Just to sort of piggyback on that, one thing that's really interesting about the European Union situation that I've been studying, maybe a little from a local government perspective, is that they're one of the few areas where you're really starting to see disaggregation between national citizenship and different tiers of membership. And this, of course, does not apply to immigrants from Africa or whatnot. But what's really interesting in the European Union is that you were to migrate from one country to another country, let's say you're a Polish immigrant into England, is that you may not vote in the English elections, but you can vote in the London elections if you live there. And I think that's interesting because we tend to think about membership as nested, right? So we separate it into different respects, but we think that the national citizenship is one thing, state citizenship is sort of connected to that, and local citizenship is definitely connected to that, right? These are all sort of the same. But historically, that was not always the case. There was one time when state citizenship was very important, and local citizenship was also different as well. I'm not saying that this is sort of this beginning of ways of thinking about it, but it's interesting to think about a national world. This is flowing into the global urbanization, global cities literature. But it's interesting to think about different tiers of membership that isn't necessarily nested within the nation-state structure. And I think the European Union was thinking along those lines that, yes, you may not be at a position to be voting in the national elections of England, but living in London, your concerns is no different than any other neighbor. So I think that produces interesting dynamics. The other only thing that's interesting, I mean, we've all known about the riots that happens in Europe, and there's actually an excellent book written about the different immigration strategies in England versus France, one being a multicultural move, and the other being sort of more of a we're all one, we're not even going to keep data on any of these things. But one thing that is really interesting is that there's definitely, I think it was reported here that a lot of the French riots and stuff like that was sort of like some sort of immigrant riot or a Muslim versus European culture riot. But what was really interesting coming out of that, besides the fact that there's this issue of physical segregation, they had the opposite, right? The cities where all the rich people live, the suburbs is where the projects are. But at the same time is that when the riot actually broke out, it was not a claim to differentness, right? It was a claim to French citizenship. And at that point, you start seeing, is this really an immigration issue, or is this no different than, let's say, the riots in Watts or other riots that we have with sort of concentrated poverty? And that's the frame that they had presented it in. So I just want to sort of tie it into broader areas of how we deal with domestic policy. Just wanted to bring up a quote. There was a book written in the turn of the 20th century. I don't know if you're familiar with Boston, but the book essentially says the problem of the North End is to be settled at our ports, and the problem of the South End is the internal social problem. If you're familiar with Boston, the North End is the Italian district, the foreign district, and the South End was supposed to be the native slums. And I think we tend to grab onto the idea, even though what I'm trying to get at is maybe they're the same problem. Maybe the North End, the South End, maybe that problem they're facing exactly the same.
I'd like to add, if I could, precisely this issue in France, where the term exclusion was coined in the 60s by Cohn-Bendit, which was a student and activist. And that's what he said. I don't know if it's a problem of citizenship, of the Muslim community, the North African, but more of an integration problem. Have they been integrated with the same possibilities, even if they are citizens? And I think when we talk about immigration, tied up to immigration, we need to talk about integration programs. No matter how many people come in or not, if a labor specialist says the United States needs so many people next year, and we give them 1 year chance to work here, there is an integration issue. And there's an example in Israel that I mentioned this morning, a program called Ulpan, because they are like a mini United States. They get people from all over, Jewish people from all over the world. But what they do is, it's a federal program where 6 months they're taught Hebrew, how to pay their taxes, how to drive, and then they integrate them. And that, I think, proves that in the long term has much less abrasiveness and problems between all these different communities and cultures, because there's one common language, for example. I mean, they can speak any language at home, but when the lingua franca, they have to understand Hebrew. We have to understand English as well. So I think we have to tie those two things up, integrating rather than excluding people. That is a little bit what's going on in France.
I would just a couple of quick observations about the European comparison to us. One is that, of course, this whole conference has in part been about inclusive versus exclusive models. It's not an either or. Really, it's a spectrum, right? And although I have advocated and defended some of our more exclusive aspects of our law, I mean, on the spectrum, we are on the far inclusive end of the spectrum compared to European countries. I mean, our laws are much more permissive, as has already been described. But comparing the debate that's going on today, in especially the UK, France, and the Netherlands, and maybe to a certain extent Germany too, the debate there isn't so much about legal versus illegal. There is a small percentage of the immigrant population in those countries that is illegal, but the vast majority have entered legally. The debate there is assimilation versus non-assimilation. And, of course, that's been part of our discussion for centuries about assimilation and melting pots and mixing bowls and all that. And, over there, but they haven't had that discussion. That's one really interesting thing. They've started having that discussion in a really intense way in the last few years. But 20 years ago, you wouldn't hear French people talking about, oh yes, they're very un-French, the people who live over there. We have the saying, we have a say, it's un-American, and you become more American over time, over your family does or your generations do. But the idea of becoming more French or becoming more English is not really part of the common discourse there. But suddenly it is, because you have this sort of a cultural clash going on, and a lot of it is over sort of the secular Western culture versus the Islamic culture that is brought in by a large wave of again, mostly legal immigrants. And I think that recent events, capture it well. A couple of departments within the British bureaucracy, you may have heard about this week before last, decided that welfare benefits could be given to multiple spouses of an individual, as long as the individual married his multiple wives in some other country that allows you to marry multiple wives. Then British law would respect that and would provide welfare benefits to all of the spouses in the family. And then to add another layer of surprise to the British people about this, the Archbishop of Canterbury came out and made some comments that were kind of supportive of that government decision, saying, well, our laws are going to have to accommodate these new cultures in the United Kingdom. And so that's the big rage there, not so much legal versus illegal, which is at the top of our discussion. Yeah, please.
I was wondering why the classification of guest worker created such a hard feeling when we were discussing reform of immigration, when I would think that a classification of guest worker brings the issue down to a local level. Because at that particular point in time, you're saying inside of a community, we need a worker. We've identified someone who will meet the economic needs of our community, and therefore they should have this particular immigration classification to serve and join our community.
Comments from the panel on guest worker programs? Mike?
I'll make a couple, but I'd like to hear what everybody else has to say about this too. I think a couple of problems with guest worker programs, both here and abroad in the past, and maybe even currently under some of our temporary worker visas. One, if guest workers stay too long, and if your intention is to have them as a guest worker and they're really a guest, and then they're going to leave, you have to probably make them leave, or you have to have some mechanism to get them more integrated. And I think in Europe, and Hiroshi and others can probably speak to this more than I can, but I think in Europe, partly because I think of German citizenship laws and other things, there have been problems with guest worker programs where you're in the second generation of these guest workers, and they're not really part of the society. So I'm not sure that
because they're not German citizens.
They're not German citizens, yeah. So I'm not sure that would be a problem here, but we'd have to develop some mechanism either to move them towards permanent residence or to make them leave after a certain number of years. The other problem, and I think this is a problem that occurred here, they're subject to exploitation by their employers. And so one possibility, and I think in talking about guest workers here, is if you had job portability, you could come for 3 years or whatever it was, but you weren't bound by one employer. That would give them more freedom to move and to also demand their worker rights. I was at this panel at Dayton last year. I was last week. One of the panelists is a woman who practices law in Mexico, and what she does is she goes and works with the guest workers here, the agricultural workers that come here for a season and go back, works with them on their worker right cases where they've been exploited. And they won't usually bring this up in the United States because they won't get invited back next year. And so they do depositions, and she does litigation support in Mexico. So we have to figure out a way that the exploitation is minimized. And then the third thing is we do, as I was talking to somebody at the break, make sure that we aren't displacing U.S. workers. I mean, we got to have some kind of mechanism for making sure we're not displacing people. Those are my thoughts.
Other comments on you, Rick?
Just real briefly. I think I think there's different ways to look at the guest worker program. I think from a certain economic perspective, it make certain sense, and there has been arguments raised that if left with the choice of guest worker or no immigration, that a immigrant may choose guest worker. I think what's interesting is to think about the broader implications of it, other than just sort of the economic benefits. And I think one of them is whether or not there's job portability. If there is not, you would obviously be very successful in certain industries, and the H-2A visa, which is the guest worker program for agricultural industries, which you tend to have a larger employer that can sort of deploy a number, has been used extensively. I mean, whether or not there are certain complications that discourage the Southwest states to use it as opposed to the Southeast is a different story. But I think on top of that, I think there's two things to think about. One is that the contribution, the economic benefits that a lot of communities are looking for, especially if you look at the cities that want to be sort of attracting immigrants, and look at the communities in which inner city neighborhoods have been revitalized by immigration and sort of the development of ethnic neighborhoods, is that those things aren't benefits that are easily captured by a guest worker program. Those are sort of entrepreneurial, those are sort of community building aspects that a guest worker program, one can argue, actually defeats. I don't know, how much of you guys have moved, but it's a very different feeling when you're moving to a community knowing that you're not going to be there versus for very long, as opposed to moving in the community and potentially knowing that this is my community. And I think, not to get all soft and, fuzzy, whatever feeling, but I think it makes a difference for a community to know that, do we have a 20% population that is only going to be here 3 years on a rotating basis, or a 20% population that may invest in the community and sort of develop it in a way. And the inner city revitalization and the revitalization of various communities have arose out of the fact that they really saw this community as something to invest in, that we care about taking care of our community, about our houses, about our roads and stuff like that, and we're gonna build off of that. And the second aspect I want to, and this goes back to a little bit of what we talked about in Plyler v. Doe and some of the other effect, is that it's not just about them, right? Whether or not we adopt a guest worker program is essentially, at the end of the day, depending on how it's structured, a big statement about us. One explanation for Plyler v. Doe, and I agree with Chris Kobach, it's not necessarily under standard constitutional analysis most sound, but one explanation that was raised is that the 14th Amendment, more than just sort of statutes and reviews and standards, is really an anti-caste principle. The idea that we, whether you want to trace it back to the Declaration of Independence, the preamble of the Constitution, whatnot, is that there is a feeling that we may tolerate certain different statuses, but at the end of the day, we don't want sort of permanent statuses to be entrenched, that our society is anti-caste, we're against the aristocracy that we evolved from. And it's interesting to see what would happen to how we see our country, or how we view the world, or how we become as an individual to have what would essentially be a more long-term caste in our society. And I point you to a lot of countries that have deployed large-scale, especially in the Middle East, large-scale migrant worker program, temporary guest worker programs. And I think it puts it adopts a certain a tenure in their civilization or their culture or their idea of the country that we may not want to embrace. We may not want our kids to be thinking along those lines.
Just to follow off that real quickly, that's exactly where I was going to go with this, is that we do have an anti-caste history and ethic, and that's one of the great things about America, is that we are all, no one is above anyone else, and no one is above a certain kind of labor. And there's one disturbing trend that accompanies the rise of illegal labor in America. There are a lot of disturbing trends, but one that bugs me quite a bit is the fact that a lot of Americans are voluntarily pulling themselves out of the workforce. If you look at Bureau of Labor Statistics information and Census Bureau statistics, let's just take teenagers, for example. When I was a teenager in the early 1980s, a much higher percentage of teenagers worked. And the kind of work we did, in my case, was washing cars one summer, another summer was mowing lawns, and another summer was driving tractor, mowing bigger lawns. But it's the kind of labor that quite often, in some parts of this country now, you do not see teenage kids doing anymore. And you can see this trend very clearly, that the percentage of teenagers pulling themselves off of the labor market. And so we're becoming a country, and I think this is especially true in California, where teenagers grow up thinking, oh, that's the kind of work we don't do. That's the kind of work the guest workers do. And that is a horrible and insidious coarsening of our culture. And, so many kids are growing up in America now never having pulled on the starter cord of a Briggs & Stratton engine. And I personally think that contributed in some strange way to me being a better person today. And I just think that we have to be careful in saying, okay, well, if we're not going to have illegal labor, we'll just replace all those jobs with guest workers who come from third world countries or developing countries, and they'll do this work for us. I just think it's horrible to say that Americans shouldn't be doing those jobs.
One thing I'm hearing in this whole discussion of guest workers, too, and I get back to what Sebastian was saying about integration, is that when you really think about immigration and immigration law and immigrant policy, you can think about this as really two questions. I mean, one is how many people do you let in, and what do you do? What do they do when they get here? You can decide you're not going to let that many people in, and those who do get in, they're not going to have much by way of opportunity or rights. You can let a lot of people in, but you could be really restrictive about what they can be allowed to do, and that's a regime that has a lot of guest workers. A lot of people in, but you're not generous at all about their status. You can let not that many people in, but once you do let them in, you treat them virtually like citizens. That's one thing you could do, and that's a scheme that says the last thing we want is guest workers, because those we want let in, we don't want in any way to be second class. And then you could what's the other one? Then you could let a lot of people in and give them a lot of Right. So I'm sure you all now have a 4-part chart in your brain, but that's the way it works. And you can position all kinds of views. But the point I'm trying to make is that Sebastian's absolutely right, that this is not just about the borders per se in the sense of who gets physically let in or even who gets let in legally, but also how you treat people. And this is why the European question is so interesting, because the European question is so interesting because of the citizenship question itself, because it's not just who you let in. And it's more of the questions like the voting, but then the voting really raises like the idea that what's interesting about the European Union also is that you've got sort of an attempt to coordinate immigration policy, and yet citizenship is by different countries, and then you have the phenomenon that it is actually very difficult, relatively difficult, to become a German citizen. My German colleague of mine, the one who said you can become German, but it takes longer than a lifetime. That's the.
That was a great quote, right?
Yeah. Go ahead. You want to follow up, and we'll probably at the end, right? So why don't you follow up and we'll. Yes.
That's a country that's known a lot of guest workers.
Yes.
And,
Yeah.
third generation.
Right. Yeah. No, my friend meant at least a lifetime, I think.
I don't have the
so I
name
guess
on me.
is it to me to adjourn this, or would you like the last word here? Okay, well then I'm not going to close this out then, but I want to thank the panelists here and all of you for your great questions.
Yeah, it's an interesting.
I want to thank all of our panelists and all of our speakers who have made this wonderful symposium so inspiring and enlightening and provocative. I'd be remiss if I did not once again encourage my friend of 27 years, Hiroshi, to stop in Tulsa for a long while, a semester, a year, 2 academic years, on his way from North Carolina to Los Angeles. He'd be most welcome. But I particularly want to thank and salute the student editors and staff of the Comparative International Law Journal. You all have done an extraordinarily wonderful job logistically organizing this, making the program and the event user-friendly for all of the audience, but also all of our guests, and focusing our attention, and through your work, the attention of many outside this room, on one of the key issues, if not the key issue, of the day. And I'd like to ask that we give a round of applause to all of you. And appropriate for a student-organized symposium, I'd like to turn the podium over for a few last words to Connor Hallisey from the International Law Journal. Connor, thank you so much.
I'll make this real brief. My name is Connor Hallisey. I'm the incoming managing editor. On behalf of the Tulsa Journal of Comparative and International Law, we'd just like to thank you all for coming today. Probably couldn't have gotten it done without you. Many of our speakers will be publishing with us in our spring issue, and we'd like to get you interested in our issues. So if you'd like to stop by on your way out, we have a table outside, and you can purchase a subscription with our journal. So thank you for everything.